Okay, well, hello and welcome everybody to LAW2021 Online Criminal Laws Shape the Debate. My name is Amanda and I work for the Solicitors Group and I'll be hosting today's event. In this live session, you can put your questions to Colin and Clive and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted questions and any live questions. So the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for any further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So moving on to introductions. First of all, we've got Colin Beaumont. Colin is a non-practicing barrister, a duty solicitor for many years, and a consultant to a large criminal practice. Having formerly been a partner within the same firm, he has been advising on criminal law for 35 years. He's also been involved in teaching the profession for 30 years and has been professionally qualified for more than 37 years, having been called to the bar of the Inner Temple in 1982 and again in October 2017. As part of LAW2021 Online, Colin's sessions included the Sentencing Act 2020 and Criminal Case Law Update 2020-2021. Moving on to Clive Smith, who has spent over 10 years at the bar practicing in London. Clive undertook almost exclusively defence work at all levels, from the Magistrates and Youth Court to the Crown Court and Court of Appeal. Clive's work spans a wide spectrum involving cases of armed robbery, kidnap, sexual offences and murder. Clive's sessions for LAW2021 Online included dealing with domestic abuse cases and digital evidence and disclosure. So to kick off, we will start addressing some of the pre-submitted questions. So first of all, we're coming to you, Colin. What is the difference between the Sentencing Act and the Sentencing Code?
Oh, yes, thank you, Amanda. I've had a number of emails about this. And of course, what you need to appreciate is that the Sentencing Act 2020 introduced the Sentencing Code. In other words, there aren't two documents, it's just the one document. We need to refer to it as the Sentencing Code. But you'll find it, of course, as you will with any Act of Parliament, on the website legislation.gov.uk. So as lawyers, we need to speak in terms of a sentencing code rather than a sentencing act.
That's great. Thank you for that, Colin. So another one for you here. Which major parts of legislation are not contained within the Sentencing Code?
Well, somewhat surprisingly, you won't find much reference to road traffic in the Sentencing Code. The Road Traffic Act 1988 is very much alive and well and still with us, as is the Road Traffic Offenders Act of 1988. So you'll still have to have regard to those two pieces of legislation. Nor will you find anything in the code in relation to early release provisions or release on licence generally. In other words, you still have to have regard to the Offender Rehabilitation Act of 2014. So those pieces of legislation sit alongside the Sentencing Code.
Colin, can I just add one little bit to that as well?
Yeah, please do.
I think one observation, I think the architects of the Sentencing Code did a phenomenal job. It's a huge piece of work, and so no criticism intended whatsoever. But I think one observation that some commentators made on it is that they didn't leave some sections blank, because one of the beautiful things we've got at the moment with the Sentencing Code is that if you're looking on certain things, so for example, minimum sentencing, all of those sections are grouped together. Of course, the risk is now Parliament passes a new piece of legislation for which there is minimum sentencing and has to add a new section into the Sentencing Act and amend the Sentencing Code. And you might have, for example, section 311 on minimum sentencing for firearms, but then you might end up having to look at section 500 on minimum sentencing for something else. And so I think that was one observation that some commentators made, that they've kept some sections clear, as it were. So if you got up to section 325 and then left it blank to section 350, you could fill in the blanks a little bit later and group everything together. So I think some people feel that was a little bit of an opportunity missed. So in the future, it might not be quite as easy to navigate. But as I say, it's a phenomenal piece of work.
It's a monster, Clive. It's not a phenomenal piece of work. It's a monster. 420 sections and then 29 schedules.
Yeah.
When it first came out, I thought my birthday and Christmas Day had come all at once. I'm the chap you avoid at parties, all right?
Thank you for that, guys.
That's all right.
So moving on to one for Clive now. So will a complainant's mobile phone always be examined in a sexual offence case?
Well, I think if you read some national newspapers, then you think the answer to that question was yes. But I think if you ask a lawyer that question, I think most of us understand and realise that the answer to that question is no. We've had several really good cases on this, which were in the notes. One of the cases, McPartland, which is a brilliant read. And there's a great line from it, isn't there, Colin, that said that the application by the defence for the complainant's mobile phone in that case was speculation built on speculation, which I think is a wonderful line for all criminal practitioners to bear in mind. In short, I say that we've had another case as well, giving guidance from the Court of Appeal, the case of BJ, although I think they've changed it. Initially, they only used the letters, and now I think they've changed the citation of it briefly. I can't remember exactly what the name of it is, but it's B and J or BJ. But as I say, the Vice President of the Court of Appeal Criminal Division, Lord Justice Fulford, gave guidance in that. And essentially saying that there needs to be a good reason for the phone to be taken. And so, for example, McPartland was a really good example of this in the sense that it was a stranger rape to the extent that the complainant and the defendant, it was two defendants who raped a woman back at one of their addresses after a night out. Neither of them had ever met her before that day. And so there's no suggestion there had been any sort of communication. This wasn't a relationship that had turned sour, for example, or a marital rape. Or a situation where they've been friends in the past and things had become sexual, for example. This was a situation where they'd never met before. Let's say the rape happened on a certain evening, and then the following day there was no suggestion of any further contact. So as I say, the Court of Appeal said in that case this was speculation built on speculation. So no is the short answer. A complainant's mobile phone won't always be taken. And I know there is also in the notes as well, I think there was the Attorney General's guideline on disclosure, which came into force on the 30th of December 2020. So very much in force with us now, which gives guidance on this as well. And actually one of the examples I think is effectively lifted from the case of McPartland in a sense of an example of where you wouldn't take a complainant's mobile phone. I think most people appreciate as well, there's quite a lot of political pressure in this area. Obviously, there's lots of discussion about whether or not sexual offences cases are underreported, under-prosecuted, under-convicted, etc. And so there's quite a lot of political pressure in this area. And I know certainly in the Police Crime Sentencing and Courts Bill, there are plans within that bill as well to make sure that complainants are without their mobile phones if they need to be taken for the shortest time possible. So this is very much a developing area. I say we've seen some really good guidance from the Court of Appeal. We've seen some excellent updates to the Attorney General's guidelines on disclosure. But I say I don't think that's the end of it. I think probably by the end of the year or so, maybe if the Police Crime Sentencing and Courts Bill is passed, then we may have further legislation in that area as well. So the short answer is no. And the other point to make is to make sure you keep up to date with developments too.
Great, thank you. So coming back to you again, Clive, with this one. If I delay in making an application for disclosure, can the court refuse my application simply because it was late?
In a word, yes. The case of Boardman from 2015 is very much an example of this. And I think we've seen further examples of this too from the Lord Chief Justice in a recent case in relation to disclosure in drink drive cases. Where an application was made late in that case, and the Lord Chief Justice said that it would have been absolutely permissible for the district judge and the magistrates' court to have said, sorry, you should have raised this sooner. I think everybody realises that the courts are under increasing pressure, and if you turn up on the day and start asking for disclosure of items which you've not raised before and which you could have raised before, I think that's the point, where you could have raised these issues before, then the court will absolutely be justified in saying no. Your application's refused, it should have been made sooner. So I think that's the point to bear in mind, that as soon as you think there's an application to be made or an issue to be raised with the court, you need to do it. And in fact, you're duty bound to do it under the criminal procedure rules. You're duty bound to raise it with the party who are at fault and of course with the court, so the court can do something about it. I certainly know, obviously not over the last year or so, but in recent years, when teaching across the country, I've discussed the case of Boardman with some criminal defence practitioners, and lots of them do what they refer to as write Boardman letters. So they will write to the prosecution and the court saying the court ordered you to do X on this date, you've not done it, and saying to the court, please can you list this case for mention, or saying to the prosecution, please can you do this within the next 7 days, or we will ask the court to list it for mention. And effectively what they're doing is they're laying down a paper trail, so that when you do get to court and you have a whinge, as it were, about the other side, and say, well, they've not done X, Y, and Z, and the court says to you, well, what have you done about it in terms of raising it with the court? You can say, well, here's the paper trail, and here are my letters, and here's where I raised it.
Sorry to interrupt, Claire, but that's true as in relation to the disclosure of unused material as it is in relation to evidence. Yeah. I mean, I'm sure all lawyers appreciate now that if you're lacking something by way of an item of unused, or you're lacking something in terms of evidence, it's incumbent upon you to, as it were, shout it to the world, isn't it? As soon as possible. You're going to get short shrift if you start making these complaints, as it were, on the day of trial.
No, there's certainly been a culture shift, Colin. I agree. And I think it feels a bit difficult for some people. It feels a little bit like telling teacher, doesn't it, that someone's been naughty? But I think there has been a culture shift, and we just have to get over that and do your job, because ultimately you're there to look after your client, aren't you? Representing their case.
That's right. But it's worse than that in the sense of the current climate, as it were, as the defence. I am the final reviewer of the Crown's case against my client. If I think that the Crown lack some sort of continuity statement, it's incumbent upon me to send them an email saying, hey, you do realise, Malcolm, you're missing X, Y, and Z. That doesn't sit easily with me. No. There's something to be said in this day and age, for clients, and I should really whisper this, but we're among friends, I'll whisper it, for clients representing themselves. Hey? Shh, you never heard that. Shh. This will be edited.
You're live, Colin. It can't be edited.
No! Now she tells me.
That's great. Thank you. We're actually coming to you now, Colin, with one. Has the code made any changes to the law as regards sentencing?
Well, let me start off by saying the rationale behind the code is not to make any significant changes regarding sentencing, but rather to codify it, to put it into one easily manageable document. If you could call any document with 420 sections and 29 schedules easily manageable. Obviously, what we don't have to do now is start scurrying about looking for the Criminal Justice and Immigration Act 2008, the Powers of Criminal Court Sentencing Act 2000, certain parts of the Criminal Justice Act 2003. We don't have to look for those anymore, because where the conviction is on or after the 1st of December 2020, we should go to the sentencing code and look no further. Now, but you'd really have to be a geek to fully appreciate it. Yes, the sentencing code has made some fairly minor amendments to the law as regards sentencing. I'll just give you a classic example, if I may. Once upon a time, if a person appeared in the magistrate's court charged with a summary offence, if he or she pleaded guilty to that summary offence and it put them in breach of a Crown Court suspended sentence of imprisonment, there was no provision whereby you could commit that summary offence to the judge at the Crown Court to be dealt with. That lacuna has been amended, and there is now a provision whereby the summary offence can be committed as well. So the judge will have that, as well as the breach of the suspended sentence of imprisonment. Fairly minor tidying up measures like that. I'd also commend to you, please, that you have a read of section 166. It's got a wonderful schedule in it that wasn't apparent in any previous piece of legislation. I'll say it again, section 166.
Just to add to that, Colin, I think the House of Lords and the Supreme Court have said for years, haven't they, that the sentencing provisions in relation to criminal law, they describe them as a labyrinth, haven't they? And I think in a way, it is somewhat a little alien to a common law jurisdiction, isn't it, to have a document such as we've got. You look at somewhere like France, for example, with a penal code and things. So I think it's very welcome, isn't it, in a common law jurisdiction to have it codified in the way it is. and should hopefully help all judges, but particularly judges who don't sit full time in crime, recorders in the Crown Court, for example.
Yeah, I agree. Particularly helpful, I would think, to counsel at the Crown Court when they're assisting judges, and particularly helpful to legal advisors in the Magistrates' Court when they're taking the magistrates through it. You're quite right. It's been labyrinthine, as you say, in its complexity. The Court of Appeal have remarked on it several times in the past. Normally, as a preamble to having a real go at counsel, for saying, and you didn't bring this to the attention of the judge, did you?
You say that, Colin.
Part of me thinks, but what about the judge?
Yeah. The judge was not given the assistance to which he was entitled. Exactly, Colin. What about the judge? But you say that, Colin. I think you will see a reduced tolerance for mistakes by Crown Court judges now as well, won't you? And counsel may well get both barrels from the Court of Appeal. And you're saying, look, you've got the sentencing code. There are no excuses now.
Yeah. Things are great at the Crown Court unless they're dealing with children and young people. Ooh, always problems there. Anything to do with road traffic, always problems there. And matters that were committed for sentence, summary offences committed for sentence. It's my experience that counsel really needs to be very helpful with the judge in these areas. No criticism of the judge. He or she probably doesn't deal with this sort of stuff very often.
Yeah, really interesting case of Gould, wasn't there, recently, Colin? Gould. It's over 100 paragraphs, isn't it, on section 66 of the Courts Act 2003.
Yeah, you were talking about a gin and tonic earlier, weren't you?
You need 2 to get through that case, Colin. Crikey.
Gould, Gould, and another. Yeah, an examination of section 66 of the Courts Act 2003. Yeah. Wow. Yeah. Good read, isn't it?
It is.
Good read. Yeah. I would particularly recommend to you paragraphs 94 and 1027.
Paragraph 88 is the most interesting one, Colin.
Oh, you say 88, I say 94.
Yeah. No, honestly, paragraph 88 is brilliant. There's a great line from the Lord Justice.
It's not as good as paragraph. No, it's not as good as paragraph 94.
Right, we'll have a vote on it next time, Colin.
Ladies and gentlemen, if you're thinking, do these two people have a life? The answer is not much.
Moving swiftly onwards, Colin.
Yeah, so moving on. One for you now, Clive. Can you talk a little bit more about disclosure management documents?
Yes, not too much to say, really. They are a creature, really, of the Attorney General's guidelines on disclosure, which is the document we referred to a few moments ago. And disclosure management documents are now compulsory in the Crown Court, and they are optional to an extent in the Youth Court and Magistrates Court, save in certain cases. So you'd expect to see one, I think, in a sexual offence or a case where there's complex disclosure. And even some road traffic cases can result in complex disclosure exercises. So you'd certainly expect to see them there. And what the Attorney General's guidelines says on them is that they should be completed in a thinking manner, which is an interesting phrase. Colin and I could tell you many a story about cases where you've looked at the unused material schedule and it's got the magic 3 letters CND next to an item, which of course stands for clearly not disclosable, not just not disclosable, but clearly not disclosable, to which most defence lawyers are shouting at, that's clearly disclosable. Has no one looked at this in a thinking manner? So that's a nice phrase to have in there, that they should be completed in a thinking manner. But also that they are a living, breathing document, in the sense that it's not just, you shouldn't just complete them and that's a once and for all tick box exercise. Think, right, I've done that now. As we all know, the duty of disclosure is a continuing and ongoing one. So it is a living, breathing document, and they should be constantly updated with where you are in the case. But yeah, worth having a look at, worth getting your teeth into. And again, I think a welcome adjustment and amendment, in the sense that hopefully it means that everything is in one place. And certainly if you are a lawyer perhaps picking up a case at short notice, it should hopefully make your life a little easier, rather than having to scramble around all the papers to see what the disclosure issues are. You can simply go to one place and should be able to see the background and the history to it all.
Sorry, Clive, forgive me, I must have misheard, but where do I go to find one of these disclosure management documents?
Well, there'll be, if you're in the Crown Court, then they'll be on the digital case system. So you'll find them there. I know that I'm not sure exactly how it works in the magistrates court. I know that many of them are currently rolling out the cloud video platform. I don't think that has anything to do with where papers are stored. But yeah, that's certainly where you should be able to find them in the Crown Courts, I think.
Thank you.
Thank you. So we're coming over to Colin now. Is the new code retrospective?
No. In a word, we're back to the sentencing code, aren't we? Introduced by the Sentencing Act, came into force 1st of December 2020, only relevant if the person is convicted on or after the 1st of December 2020. If you were convicted prior to the 1st of December 2020, then of course one must look to the old pieces of legislation, the Powers of Criminal Court Sentencing Act 2000, the Criminal Justice and Immigration Act 2008, the Criminal Justice Act 2003. These are the bits of legislation that apply for all convictions pre the 1st of December. Of course, it may be that you were convicted before the 1st of December, given a court order which you've now breached. And of course, the breach proceedings are after the 1st of December. So what? You were convicted prior to the 1st of December 2020, and one must therefore look to, of course, the old legislation. As you'll appreciate, we're now in June 2021. With the passage of time, this aspect will become less and less relevant, because you'll be dealing with fewer and fewer cases where the people were actually convicted prior to the 1st of December 2020. But no, it is not retrospective.
It's going to help hugely, though, in historical sex cases, I think, isn't it, Colin? I know those are the sorts of cases that often trouble the Court of Appeal, don't they, in terms of sentencing and what powers were available to the judge. And actually having that all codified and in one place, I think is going to be hugely helpful. I certainly know when I was still in full-time practice, I remember going into colleagues' rooms and they'd have old archbolds all lined up on their shelves behind. And it wasn't just because they were lazy and couldn't be bothered to throw them out. It was because actually it was very helpful. If you had an offence from 1998, for example, it was helpful to have a copy of Archbold 1998 to know what the law was back then. Absolutely.
I mean, the Sexual Offences Act 1956 is still very much alive and with us. So, and the old editions with the old commentary, the old cases in relation to the 56 Act, still hugely relevant.
Yeah.
That's great, thank you. We've had a live question come in, so forgive me, I'm not sure who to direct this one to. So with AG's reference number 1 of 2020 in mind, how does a jury/JJ decide whether touching is sexual? How is purpose different from intention?
This is a really interesting case, isn't it, Colin?
We've discussed this, Clive, haven't we? Absolutely.
Yeah.
One can understand why the Attorney General took this particular matter to the Court of Appeal for some guidance on it. But as I've said to you in previous conversations, Clive, having read what the Court of Appeal have said, I find it difficult to marry it up with the wording of the actual section.
Yeah. Just for those not familiar with the case, just to go through the facts very briefly, I think a gentleman got on a train in York, maybe, and he was alleged to have kissed a woman whilst on the train. And she called the police and he was arrested for sexual assault. His defence was that there were some people who were taunting the lady, saying that she wasn't very attractive, and to try and sort of disperse the situation, he leant over and gave her a kiss, although I think she disputed the facts somewhat. So hence the question whether or not it was sexual, whether or not he was just giving her a kiss to try and make her feel better and there was no sexual intention behind it, or was it, as she said, that it was an unsolicited kiss and there was no background to it. So those were the facts. So it was quite an unusual set of facts, wasn't it, Colin? But almost the perfect set of facts to decide the point on, wasn't it?
Yeah.
But yeah, as Jeff Parby says in the question box there, how do you decide whether touching is sexual? How is purpose different from intention? I think and I think our view is, Colin, certainly your view is that the Court of Appeal's decision does not reflect the intention of Parliament, because the question here was whether or not the defendant needs to have a sexual intention to be guilty, or whether or not it's the complainant's perception of it being sexual which makes them guilty. And the Court of Appeal effectively said that if the complainant or the victim ultimately feels that it was sexual, then that's the overriding factor. Whereas, of course, if you read the legislation, so in terms of, as you quite rightly point out in the question, in terms of purpose and intention, it seems Parliament says that the person's intention must be sexual in order for them to be guilty of the offence.
I mean, if you look at Section 78 of the Sexual Offences Act 2003, it says the section reads, because of the purpose of the accused, because of the purpose of the accused, it was sexual. So it seems to me that's Parliament saying that it's not sexual unless it's the purpose of the accused that it deemed to be sexual.
Yeah.
Well, if that's what Parliament has intended, it's difficult to see how a person can be convicted of such an offence where he or she does the act for perfectly laudable and understandable reasons that have nothing to do with the purpose of it being sexual. I think, quite frankly, we're in a bit of a mess on this, Clive, is the honest answer. Is the honest answer to the question.
Yeah, I wouldn't be surprised if we had another case in front of the Court of Appeal soon. Because the interesting thing about this as well, of course, is that the defendant was tried and acquitted before a High Court judge at Nottingham Crown Court. And again, we've had this conversation before, Colin. You know, High Court judges don't always come to their decisions on their own. They will have spoken to their colleagues about this. You know, other High Court judges and potentially even Lord Justices of Appeal saying, look, I've got this case in front of me. What do you think about this point? And they would have kicked it around themselves, wouldn't they, before hearing the arguments in court? So very, very unusual for a High Court judge to be overturned by the Court of Appeal. And as you say, Colin, I don't think the Court of Appeal have done us any favours. It wouldn't surprise me if we saw further case law on this.
Yes. I mean, as a jury member, I think I'm entitled as a jury member to come to the conclusion, yes, okay, he did it, but his purpose in doing it was not sexual. I'm therefore not going to find him guilty of a sexual act.
Interestingly,
of course, that's if I believe him. If I don't believe him, then I'll find him guilty. But if I believe him, the troublesome point is, if I believe him, am I still obliged then to find him guilty?
Of course, he was also acquitted of common assault, Colin. There was also common assault on the indictment, which was interesting.
Yes. Good. Can I just say, excellent question. And we're all in a state of flux, I think, at the moment.
Yeah.
Well, that's great. Thank you to you both. So I've got another question here for Clive, I believe. Should a judge always give a ruling on hearsay before closing speeches?
So this is the case of Kiseltan that was in our notes that we talked about from the Court of Appeal. So this was a situation whereby the judge, as everyone knows who's seen the course, that the judge didn't give the ruling until after closing speeches. And this is very common in the Crown Court. You know, the judge wants to get on with the case. You don't want to keep the jury waiting, etc. So very often, especially at the end of cases, when the jury go out, the jury might be out for several days. The judge then keeps counsel in court for sometimes an hour, hour and a half, whilst they give their rulings. Sometimes they give you a written copy of their ruling too, but they'll often give their ruling then to put them on the record. And it's a time-saving device, which you can absolutely understand from the judge. But of course, the issue is if the judge doesn't give a ruling on hearsay before the advocates make their speech, the question is, what are you saying about the hearsay in your speech? So it's a little bit in terms of putting the cart before the horse. However, the other thing to say now, which I think I mentioned in the talk on this anyway, is that, of course, that summing up in the Crown Court is become significantly different over the last year to 18 months or so, in the sense that judges now very frequently give split summings up. So they will start off by giving their directions on the law. Counsel will then make their speeches, and then the judge will finish off their summing up by giving them a resume or summation of the facts. And as a result of that, we should hopefully avoid the situation that you now get in the case of, we had in the case at Kiseltown, because the judge should now be giving their directions to the jury, which will be as a result of their ruling and their judgment, before counsel are making their speeches. And I understand anecdotally, speaking to a friend of mine who sits as a recorder, that as a result of this change, he said that quite often what you're finding now in the Crown Court is that counsel's speeches are significantly shorter. Because, of course, all those points of law and areas that they would need to deal with, for example, the burden and standard of proof, the prosecutor will mention it, the defence advocate will mention it, and then the judge will mention it. However, if they've already heard that direction from the judge, then there's little value and merit, is there really, in the prosecution advocate and defence advocate saying much more about it. So say that anecdotally, I understand, has been one of the side effects of it too, which is hopefully a good thing.
Yes.
So one for Colin now. So how is the judge to work out the percentage reduction when sentencing a child or young person?
Okay, let's define the terms first of all. If we're dealing with children, we're dealing with people aged 10 to 13. If we're dealing with young people, we're dealing with people aged 14 to 17. Adults, of course, are 18 plus. Now, the point is this. We've got lots of guidelines issued by the Sentencing Council in relation to sentencing and the quantum of sentence that should be imposed. However, you'll look long and hard to find any guidelines concerning quantum for children or young people. I had an email only the other day. Colin, I can't find the guidelines in relation to how much in terms of a custodial sentence my client should receive, my client being 17 years of age. There don't appear to be any guidelines concerning people who are 17. Well, it was an interesting email. Of course, the answer lies in the document published by the Sentencing Council, overarching principles, the sentencing of children and young people. That is an excellent guideline document. It was published by the Sentencing Council on the 1st of June 2017. If you haven't read it yet, might I suggest you visit the Sentencing Council website and download that particular document. I'll give its name again: Overarching Principles, the Sentencing of Children and Young People. And the Sentencing Council did this. It's not a rule of law, or it's just a general principle. But when a judge is considering how much in terms of quantum, obviously the judge will need to take into account the age of the offender, and where the offender happens to be 15, 16 or 17, a young person, 15, 16 or 17, the judge should be looking at the adult guideline and then applying a percentage reduction of something in the region of perhaps a half to 2/3. In other words, that 15, 16 or 17-year-old should be looking at a half to 2/3 of the amount that would have been appropriate for someone 18 or over. The guideline also goes on to say that where the person is below 15, 14 or below, effectively the court may consider it appropriate to give a sentence of below 50% of that which would have been appropriate for the adult. And it is merely a principle. It is not a rule of law. And we had a judge the other day at Nottingham Crown Court who, as it were, said, yes, I've considered the principle, but I've decided not to apply it in this particular case. It went to the Court of Appeal, and the Court of Appeal said, yeah, that's fine, so long as the judge considers it as a principle and gives reasons as to why he or she isn't following that particular principle, then there's nothing wrong with that. This is all to do with the discretion of the judge, and the Sentencing Council has merely given some guidance on the point, but it's not a rule of law.
Colin, should that reduction take place before or after applying the credit for a guilty plea?
it should definitely take place before applying the credit. The thing to bear in mind is that you apply the credit as the very last part of the sentencing exercise.
Yeah, because that's a mistake that some people have been making as well, isn't it? Applying the reduction for credit and then reducing the starting point then.
That's right. And mathematically, without boring you about the maths, mathematically, a young person may lose out because he or she might, as it were, have been warranting a full 1/3, whereas an adult might only have been given 25%. So you do it as the final part of the sentencing exercise. And mathematically, it does make a difference to the sentence if you do it as the final stage.
Yeah.
Says he, who didn't get O-level maths. Oh no, we're being recorded. Carry on.
Thank you for that one. So one for you now, Clive. If a witness doesn't turn up on the day, can I just make a hearsay application?
Prosecution or defence?
Oh, either. Yeah.
Here we go. Is this person a prosecutor or defence lawyer?
I think it's probably a prosecutor. We can speak about it from both sides, can't we, Colin? I suppose the short answer is yes, you can make the application. I suppose the second question is, though, will I succeed? And the better question really is, will I succeed? We had the case of wills and DPP, which I think I mentioned in the talk about making res gesta applications on the day. Because the case of wills followed 3 other cases in relation to res gestae, where the res gestae evidence had been adduced by the prosecution of the complainant in domestic abuse cases. But the difference in those 3 cases, in the cases of Ibrahim, Morgan and Barnaby, was that the Crown had always signalled their intention at a very early stage not to rely on the complainant as a witness. So they were always making a res gestae application. I think they'd made that point very clear from the first appearance. In the case of wills, what happened is it was a domestic abuse case where I think it was the stepfather and stepbrother who were alleged to have assaulted their stepsister. And the Crown had taken a statement from her and had fully expected her to turn up on the day of trial, and she didn't. And so when she didn't turn up on the day of trial, they then sought to make a res gesta application, which the magistrates acceded to. They allowed the evidence to be read and they convicted the 2 defendants, who then took the case by way of a case stated to the divisional courts. And the divisional court said no. They said, just because we've done it in those 3 cases, this is different. They said, in this case, you'd always intended to rely on the complainant. It was always your intention that she turn up and give live evidence. If she doesn't turn up and give live evidence on the day, then you need to find out why she's not there. Because otherwise what you're doing is you're effectively circumventing section 116 of the Criminal Justice Act, which has the 5 criteria for the prosecution or the defence being able to adduce evidence of an absent witness. So, for example, they might be dead, they might be unfit to attend, they might be outside the jurisdiction, etc. They might be in fear. So those are the reasons that Parliament has laid down to say, look, if you haven't got a witness or you can't get a witness to court, these are the exceptions to the rule, as it were. These are the situations when you can adduce that evidence. So I'm not saying never in relation to res gestae, but if they don't turn up on the day, the case of will says it's incumbent upon you, before jumping to making the res gesta application, to find out where the complainant is. They didn't use the phrase best evidence rule, but I think we all know what we mean by that. You know, the best evidence is having the witness in the witness box giving her evidence. So you can't just say, oh, well, she's not here. We'll just shrug our shoulders and say, well, we'll do it a different way. Then we'll just read the witness statement. Wills was saying, no, you can't do that. You need to actually make a full investigation and find out why she's not there, because you might have another application. You might have a different application that she's in fear, or you might have another application that she's unfit to attend court, and whatever it is. So you can't simply fall back on the res gestae principle, as it were, to sort of resolve any issues you might have about not getting a witness to court.
I mean, the High Court said in the case of Randall, Regina and Randall, that it was a duty upon the Crown to muster their live witnesses and to put those live witnesses in the witness box and render them subject to cross-examination. And of course, to go from that straight to, oh, this statement's being read as a hearsay statement with no opportunity for the defence to cross-examine the maker of that statement, where you shouldn't you shouldn't be doing that unless there are jolly good reasons as to why that statement needs to be read. As you say, Clive, those jolly good reasons as to why a statement needs to be read being set out in section 118 of the Criminal Justice Act 2003.
116, Colin.
116, I beg your pardon, 116.
118 is res geste.
Res geste, of course, is 118.
Yes.
And there's a reference in the question to res geste.
Yep.
But of course, if I were a prosecutor and my witness hadn't turned up, legally, might I try it? Well, I might try it. Section 1141D, Section 1141D, Criminal Justice Act 2003. Let's see what the defence say, because they're jumping up and down, aren't they? Let's see what the legal advisor says.
Yeah. Well, there's the good case, Colin. I'm not sure if you come across this one, the case of Z, which is in the notes that I talked about during the presentation, that on the one hand, of course, you've got 116 that says these are the 5 criteria under which you can read a witness's statement. Yeah. And then, of course, you've got section 114(1)D in the interests of justice.
Yes.
And what the Court of Appeal was saying that is that although you might have, so in the case of Z, for example, it was a sexual abuse case where, or a sexual offence where the complainant had previously been cooperative with the police. The case had gone nowhere and the Crown had decided to do nothing with it. And a few years later, they decided to reinstigate proceedings. And the complainant, he said, no, thank you. He said, I'm not interested. He said, we've been through all this before. He said, I'm not going through all that again. Thank you very much. So they had a complainant who was available to give evidence, but he was just unwilling and uncooperative. He didn't want to be involved, and which, of course, doesn't satisfy any of the criteria, does it, under 116?
No.
And so what the Court of Appeal said in Z is, look, you have to be careful with 1141D in the sense that you can't add further criteria to the list under 116 because Parliament has said these are the 5 reasons why you can read a witness's statement. But on the other hand, if you use it too restrictively, then what's the purpose of section 114(1)D? So you've got to find a balance somewhere in the middle. You can't just say, well, everyone can therefore give evidence under section 114D, but equally you can't be so restrictive to say no one can. Otherwise, you render a lovely word, Colin, you render section 114(1)D nugatory.
Nugatory, wonderful word, nugatory.
Not used enough, Colin.
And as the High Court said, effectively, you'll know when you get it wrong. Why? Because we'll quash your conviction.
We'll tell you. We'll mark your homework for you.
Excellent, excellent. Damned if you do and damned if you don't.
Yeah.
Sometimes.
Yeah.
Thank you for that, guys.
I was shocked when I first read 1141D. I thought, oh, yeah. The words floodgates and opening come to mind.
There may be trouble ahead.
There may be trouble ahead. What are the magistrates to make of this? The first time ever they've been able to say, yeah, we'll have hearsay, even though there's not an exception at common law in statute. So what? We'll have it in 1141D. I thought this will produce a bit of case law. I thought this will put the cat amongst the pigeons.
Yeah.
Sorry, Amanda.
That's okay. Question for you now, Colin. Will sections 76 and 78 of PACE have any relevance when considering the admissibility or otherwise of the evidence obtained via EncroChat?
EncroChat, yes, EncroChat. And obviously I've given you the case law in relation to EncroChat. I won't go on about it. Suffice it to say, of course, that, and Clive will have his say on this as well, I think I'm right in saying that these criminals were talking to each other, as it were, secure and safe in the knowledge that it was all encrypted end to end. Well, it was until it wasn't. Yeah, until the French and Dutch authorities cracked EncroChat and managed to retrieve all of these conversations between these criminals, who, of course, had been rather cavalier in the words they'd used, even talking about drugs and guns, and even talking to each other using their real names. Well, we know, don't we, that there are a number of cases going through the Crown Court at the moment where a large part of the Crown's evidence will be the evidence obtained from the authorities abroad as a result of EncroChat being de-encrypted. Having said that, the question relates to what about putting forward applications under sections 76 and 78 of PACE on the basis that although this evidence could be adduced as part of the Crown's case, it ought not to be adduced because to do so would be to render the trial unfair. And I'm sure that even as I speak today, that those arguments are being put before Crown Court judges. Judge, don't allow this evidence to go in. It offends sections 76 and 78. Clive, you're probably of a similar view.
Yeah, undoubtedly they'll be putting these arguments forward because, as you say, Colin, the difference between this sort of phone evidence and text messages that they've got is that a lot of criminals have been caught with their trousers down, in the sense that most criminals, when communicating, first of all, as we know, they'll use end-to-end encrypted communication, so things like WhatsApp maybe, but they'll also speak in code. So, for example, if you've got a gun, I wouldn't text Colin and say, Colin, have you got the gun? Are you bringing it over? What we do is we give it a woman's name, don't we, Colin? Colin, is Rachel at yours at the moment? Is she coming over this afternoon? No, she's going to stay at mine, have some dinner, and then I'm going to bring her over in the morning to see you. So say that they all speak in code and in riddles. They do the same with drugs and various things. But say they've very much been caught with their trousers down here, haven't they? Speaking very candidly about what they're doing. It leaves no room for imagination. They're spelling out what they're doing in all these chats, aren't they?
You know, a little bit of forethought goes a long way. I mean, I think as a criminal, I'd be tempted to think, yeah, well, I'm safe today, but nothing lasts forever.
Yeah.
I might not be safe tomorrow, and so I'm still going to refer to my Kalashnikov as Amanda, if you don't mind.
Yeah. Colin, there's been a similar system. It was on the news about a week ago that's been busted, I think, in Australia, whereby I think the FBI had paid a convicted criminal to set up a system. And they just carried out a load of raids in Australia. I'm not sure it extends to England or Europe or anywhere, but yeah, there's similar systems around the world now that are getting broken down by law enforcement agencies. So I dare say this won't be the last we see of this.
No. Or if you want to use the word used by the criminals, Clive, they're being hacked.
Yes, exactly.
Disgraceful. Yeah. They're being hacked.
The hackers are being hacked.
Is there no justice in the world, they say?
Thank you for that. So on for Clive now. Would a 30-minute delay after a domestic abuse incident mean the evidence was not admissible as res geste? Res
geste, yeah. It's a difficult one, isn't it? Possibly, maybe not. I think everyone, and even magistrates, I think, wish that there was a flow chart whereby you said if someone made the comment 15 minutes afterwards, that was res geste. If they made it 16 minutes, then that wasn't. But it's not, is it? It's not as simple as that. And I often give the example of somebody, a woman, for example, might have been held hostage by her partner for a week or two. And, the police come, they free her from the flat where she's been tied up, etc. And they sit her outside and they give her a cup of coffee. And half an hour later, she starts telling them what happened. Would that be res geste? I think undoubtedly it would. The question being, what happened still dominating her mind at the time? Then undoubtedly yes, because she's just been through this terrible ordeal for several weeks. And it might even be that someone's kept hostage for a month or so and is then spoken to the next day. And you might even be able to try and apply and get that in as res geste. Equally, you might have an incident which lasts 30 seconds and the police turn up, they're called, and they turn up half an hour later. They arrest the suspect, put them in the van, and they go and speak to them. Would that 30-minute delay amount to res geste? Probably not. No, it was a 30-second incident. If it wasn't particularly dramatic or traumatizing, it wasn't necessarily still dominating their mind, then possibly not. So, as I said at the start, really, it's not as simple as having a flow chart whereby 15 minutes and you're in, 16 minutes you're out. It's always going to depend on the circumstances of the case. And the Court of Appeal have said the delay in making the report is but one factor to be considered. So it's not the decisive or determinative factor. It's just but one factor to be considered in all of it. And I think the other positive, I think, particularly for the prosecution these days, is that many of these comments are now either recorded via 999 calls or they're recorded by body-worn video footage. And so rather than the magistrates or the district judge or even the Crown Court judge trying to get a picture of it in their own mind of what was going on at the time, they get a live version of it effectively, that they're able to see, look, these were the circumstances that were prevailing at the time. What do you think of this? So I would hope, certainly with that sort of evidence available to the courts to make the decisions, that they're making more accurate decisions as well, because they're not relying on somebody else's impression or report of what they look like or how distressed they were, etc. They can see for themselves.
Yes, and of course the statement falls in the res gestae exception if we can say that the maker of the statement, whilst making the statement, was so overpowered or overcome by the event that we can rule out the possibility of distortion or concoction. And that may well be true several hours after the incident. This particular person may be traumatized.
Yeah,
they might not speak. They might not speak until the following day.
Yeah.
It's not merely the passage of time. You make a good point about the body cam footage. Well, let's play the body cam footage. Let's have a look at the demeanour of this person. Are they traumatized? Are they overcome? Do they appear okay on the video footage?
Yeah.
I think a good piece of body cam footage is worth 1,000 statements.
Definitely. Yeah.
That's great, thank you guys. So one for Colin now. What will the position regarding the extension of custody time limits be as we move out of the COVID-19 pandemic?
Well, we know, don't we? We had that statutory instrument late last year which said that in relation to people awaiting trial at the Crown Court, they'd extended the custody time limits, hadn't they, for adults, so people could effectively be in custody for a good deal longer than 6 months before an application for an extension was required. I don't remember off the top of my head what the days were, but it went from 6 months to near enough 7.5 months. Before an application was required. But I do seem to recall, Clive, you'll correct me if I'm wrong, I seem to recall reading something in that statutory instrument to the effect that it had a shelf life and would finish in June 2021.
Oh, did have a sunset clause?
Yeah, we're in June 2021 now.
Yeah.
So what's going to happen? What's going to happen? Yeah. Are we going to get a new statutory instrument, or are we going to revert to 6 months as being a custody time limit, and then the need to apply for an extension?
Yeah, well, I don't think the backlog's got any better, Colin, so I suspect that sunset clause might be renewed.
There you are.
Yeah.
There you are. Certainly in that statutory instrument, it did say that this new extension would only apply until a given date in June 2021.
Yeah, sunset clauses they're referred to, aren't they, as Colin? So it's a way of getting them through Parliament and receiving cross-party support. Really, they're saying, well, no, absolutely, it's wrong that you should be extending custody time limits for permanently, potentially, on this basis. And they're saying, we're not doing it permanently, we're not doing it forever, we're just doing it for a focused period of time, and then we'll review it. And quite often the other parties will say, well, that's fair enough, we are in the middle of a pandemic, so that is reasonable. But yeah, you can only have it for so long, is what they often say, isn't it?
And you make a very good point about the backlog. So it may well be that is going to continue, but it will require a new statutory instrument. I think my understanding is you can't amend a statutory instrument. You have to give us a new one.
Well, that's the whole purpose of a statutory instrument, isn't it, Colin? That it's effectively delegated authority to a minister, isn't it? Yeah. So if that minister's got delegated authority, it's not as if you have to go through, not like passing a new act to Parliament, is it? It should hopefully be a, waving it under the minister's nose and getting them to sign it job, really, shouldn't it?
And I know there's increasing concern, isn't there, amongst lawyers, that more and more legislation, as it were, speaks in terms of, yes, and this will be decided, as it were, by statutory instrument.
Yeah, avoiding parliamentary scrutiny, as I think lots of people suggest.
Indeed. We need a bit more parliamentary scrutiny, chaps.
No, you don't. You remember the old saying, don't you, Colin? Those who like sausages and the law should never watch either of them being made.
He's on form today.
We don't need more parliamentary scrutiny, I can promise you that. It's not pretty.
Over to you, Amanda.
So we'll see how we get on. This might be the last question, but we will see. For Clive, how can I help a witness who cannot remember what she said in a 999 call?
This is a great question. It was something I was reading again recently, section 139 of the Criminal Justice Act 2003. As Colin says, we don't get out very much. But as everybody knows, section 139 is the section that allows a witness to refresh his or her memory from their witness statement. So it's a great section. If you've got a witness who's stumbling a bit and they're having trouble remembering, you can ask them, or you can seek leave from the court to see if they want to refresh their memory from their witness statement. And obviously, in long cases where witnesses are giving evidence over several hours or even several days, you can imagine it's very helpful. But sometimes even in short cases, it can be very helpful as well. You might have a nervous witness, which is not unusual either, who's struggling a little bit. But the great thing is, if you have a look at section 139, section 1391 says that they can refresh their memory from a witness statement. Section 1392 says that they can refresh their memory from a transcript of a statement which they've made. So the types of witnesses we're thinking about here are, firstly, cases of usually sexual offences where there will be ABE interviews, so achieving best evidence interviews, where they've been recorded giving their statement on a camera, usually in a sort of what's often referred to as a soft interview room, so an interview room with sofas and tables and cups of tea and things, instead of the sorts of interview rooms you might see a suspect being interviewed in a police station. So they'll be interviewed there, and then afterwards what often happens is a transcript will be prepared. And so the use of that transcript is usually put is to assist often the jury or the court with following what the person's saying. But of course, as I say, if your witness is struggling in giving their evidence and there's something in their transcript of the interview they've given, then you can use that to refresh their memory. And of course, the other obvious place that you can do it is to remind them of what they said in a 999 call. So, a point to prosecutors, really, if you think you've got a witness who might be struggling a little bit and you might want to help them by refreshing their memory of what they said in the 999 call, the prerequisite is that you will need to have a transcript of that 999 call. So they can't, if you read section 139(2) strictly, they can't refresh their memory by listening to a recording. It has to be from a transcript of it. But as I say, it's one of those little bits buried at the end of section 139. I think most of us rightly think of it about refreshing memory from a witness statement, but you can also refresh your memory from a transcript of a 999 call, for example, or even an AB interview.
No, that's great. Thank you very much for that, Clive. So unfortunately, we're at the end of our time for today. Thank you for attending Law 2021 Online Criminal Law Shape the Debate, hosted by the Solicitors Group. Big thank you to our expert speakers today, Colin Beaumont and Clive Smith. Don't forget to join the Solicitors Group's Law 2021 online community on LinkedIn to continue the debate after the session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within 48 hours. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinars. Feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. Please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk. By visiting the exhibition, you can access a free 1-hour CPD webinar from our webinar learning catalogue worth £35 plus VAT. So what's left for me to say thank you again and hope you enjoy the rest of your day. Thank you, everybody.
Thank you, Amanda. And thank you to everyone. Thank you to everyone out there. Look forward to seeing, hopefully, face-to-face in 2022. Hey, there's a thought. Bye.
Bye. Thank you, everybody.